Hello, everybody, and welcome to Weber Gallagher University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. My name is Paul Fires, and I'm presenting today by Zoom, along with my Zoom partners, Stephen Potako, to discuss Pennsylvania updates, Jennifer Laver to discuss New Jersey updates, and Geoffrey Lockyer to discuss Delaware updates. You'll find a copy of this presentation and others at our website, www.wglaw.com, under the Weber Gallagher University page. Simply go to our homepage and click on the Weber Gallagher University icon at the top right side of the page. And of course, if you have any questions at all, feel free to contact us directly at questions@wglaw.com. That's questions@wglaw.com. Today's presentation is the sequel, if you will, to our initial coronavirus and workers' compensation presentation, which first aired on March 9th, 2020, and is still available for viewing. However, much has happened in each of our states since that time, not to mention what is going on nationally and worldwide. So let's dive right into it. We'll be reviewing the following topics by state: the state of the workers' compensation practice in each of our states, COVID-19 cases, what clients are telling us about the kinds of cases being brought, what we are seeing as client reactions to those cases, what options are available to claimants alleging COVID-19 in each state based on current legislation, what options are available to clients in each state, the status of any attempts at legislative changes in each state, whether any of these states will, and I say this in quotes, open up anytime soon, and finally, have there been guidelines for how to run a non-essential business once they reopen? So, Steve, as we tend to do traditionally, let's start with you. How would you characterize the state of coronavirus practice in Pennsylvania?
Well, fortunately, Paul, our workers' compensation practice continues, not exactly normally, but we're still having hearings. The hearings are in the nature of compromise and release hearings conducted telephonically. We have pretrial hearings, status hearings. The only limitation I've seen is we're not able to conduct full hearings with witness testimony effectively yet. I know there are plans on the books to correct that, possibly using Skype video, but until we're able to get back in the courtroom, which may be some time off, we're still going to have to work remotely. I understand depositions are still being conducted, again through remote telephonic means, and some medical examinations are still proceeding. We are one of the court systems that is fortunate enough to have the WICAS system that allows us to do quite a bit administratively, and a judicial system that is progressing while so many other court systems are essentially shut down.
And cases are being settled, aren't they?
Oh, that seems to be most of my day, is settling cases and having CNR hearings and all the setup involved in that, which again must be done remotely. But yes, settlements are certainly proceeding.
So that's good. That helps lower reserves. How about in New Jersey, Jen? I know New Jersey has been hit pretty hard by the COVID-19 virus. What's going on in the workers' compensation world over there?
So for New Jersey, all the courts are still closed for in-court appearances. It was just pushed back, so right now they're closed until May 11th. But the supervising judges in each of the courts are the ones that are handling all the lists. So for some of them, that's a lot of work because there usually are 3 or 4 judges in some of these court locations. Some of the judges are doing Zoom. Some of the judges are doing just telephone conferences. Some of them are just doing where they want written communication. Settlements are going forward, but again, it's a judge-by-judge situation as to how everything is getting resolved, whether or not it's by phone or by video. Sometimes they're asking for stipulations to be sent by certification instead of verbal certifications. So they're doing things a little bit differently, but everyone is moving things along. Similar to what Steve had said, what's not taking place really is the live testimony. Motions for men in temp are being handled on a case-by-case situation. If testimony is needed, it will be done by telephone or by Zoom, and in a rare situation, they would allow for live testimony, but so far I haven't heard of that happening. But they are moving forward with settlements. Things are a little bit slower because the court staff really isn't there. So for some cases, I get the settlement orders the next day, and other ones, it's taking the judge staff a week to get them to us. So they are being done, but it depends on where you are, what's going on. So, but for now, we're not going to have any court testimony or any in-court appearances until at least May 11th.
I understand. Jeff, how about in Delaware? I know Delaware is the first state. Tell me what's going on down there.
Well, the state of workers' compensation practice in Delaware is actually pretty strong, I would say. As of April 13th, the board provided the option to parties to conduct full hearings with witnesses by Zoom or WebEx, basically by video. Both parties have to agree. They have to sign off on allowing for a hearing officer to hear the matter, and also some other stipulations in terms of pre-marking, pre-submission of exhibits. But they are willing to do it if the parties are willing to do it. So that's a nice plus. They are granting continuances very generously in the event a case is not suitable. Sometimes you may have a claimant that's not able to access the technology, et cetera. But depositions are all proceeding as normal as could be via telephone for the most part. All filings are running promptly, and everyone that works at the board for the Industrial Accident Board has been great in terms of approving settlements, getting petitions docketed, and otherwise just conducting the administrative work very smoothly. Thank you.
I live in Montgomery County, Pennsylvania, and I work in Philadelphia, Pennsylvania, and many other cities as the case arises. And I know near where I live, hospitals are still very much overwhelmed, and the curve hasn't yet flattened. But there's a whole variety of cases that the doctors are telling me they see in these hospitals. Steve, in your experience, what are your clients telling you about the types of cases being brought and the types of allegations being made?
I have almost daily conversation with adjusters who tell me they are seeing claims at the administrative stage. Not too many of them are in litigation at all, but they're being reported. And the reports are on the gamut from, I think I've been exposed, I'm not even sure, to I just came out of the hospital with COVID-19, and I think the exposure came from work. So the adjusters are seeking guidance for what to do with those claims. Many of them are taking the full 21 days to try to investigate, to establish whether the person actually had COVID-19, because that requires some medical confirmation. In other cases, the exposures are far less obvious in the workplace. There may be somebody in the plant or the building that had it, but that doesn't mean the individual acquired it from that person. Could have acquired it elsewhere. These are the questions the adjusters are approaching us with. Now, I've spoken with claimants counsel, and I know at least one firm has 3 death cases already, unfortunately. They have not brought litigation yet, but they are in the investigative stage, we'll say. So these are the types of claims we're seeing. Often the exposures are very limited. You know, a person passing through may have an administrative role or financial role in a hospital, but they walk through the emergency room. They wind up getting sick. They're sure that's where the exposure was, but who knows, really? So that's what I'm seeing.
Jen, you know, it's funny. I've also talked to a lot of adjusters, and I'm hearing the kind of reaction to cases that I never hear with low back strains or bumped knees or head contusions. People hear employees complaining about or alleging a work-related COVID-19 infection, and the first thing they ask me is, should I accept it? And that's a question they'd never ask me if it was any other kind of alleged complaint. What are you telling your clients in New Jersey who bring that question to you?
It really depends on who the client is. New Jersey has 2 different parts of the statute that would affect this type of situation. So as a result of 9/11, they have what was enacted, and it's called the First Responder Statute. That gives the employee a presumption that they got the condition at work. Now, otherwise, it would be whether or not the condition is more probable than not. And the situation we currently have is it depends on whether or not an individual is covered under the First Responder Statute. If so, it's obviously going to be easier for them to prove it's work related. And so in those situations, you still have to investigate and you still have to evaluate. So it's not a rush decision, regardless of whether or not the presumption is there. You still have to do a thorough investigation. And a lot of times we say, don't necessarily accept or deny, but evaluate it and consider paying, whether it be paying temp without prejudice or the employer offering to pay the time while they are being quarantined or treated. So it really depends on the facts. It depends on what type of job they have and whether or not they would be covered.
Jeff, let's consider some Delaware employees, for example, healthcare workers, delivery workers, food service workers, essential industry workers, members of police, fire, or National Guard forces. In Delaware right now, is there any kind of favorable presumption for them? What would you tell clients who tell you that they have a population of employees that fall within those groups? What do you tell them when the employee informs them that they believe they have a work-related COVID-19 infection?
Well, I've certainly had that discussion with those types of employers. And in large part, when it's a direct exposure type situation, even if someone's been in contact with someone they know is positive and now they believe they are positive, maybe they didn't get a test made available to them, or maybe they did and it was positive. The position that we're taking still is that, this is a pandemic. It is everywhere. So you may have been exposed 5 times on your way to work and not known. And for that reason, we're still viewing it as not a work-related compensable injury. What I'm also seeing a lot of are, and probably more so than even direct cases, are indirect, what I would consider sort of auxiliary claims to direct infection. It's my business shut down and now I have people on light duty and they're laid off and now they're filing for reinstatement. You're seeing a lot of that. So to me, what I've personally been seeing more of are the indirect causes and repercussions from the virus. Almost in a way, the direct ones are easier to defend because you have the whole pandemic situation. So that's basically what I've been seeing.
Are you hearing about claimants, Jeff, retaining lawyers to bring cases? Is that starting to bubble up in Delaware?
Yes, it is. They are bringing cases. We have some that are active now. They are the auxiliary cases, like I said, someone that is on restrictions or the business shuts down and now they're looking for a reinstatement of benefits. The direct cases, I think, are more the way Steve described them, that you get a lot of questions, the cases are there, but they're still being handled without litigation at this point.
And how about in New Jersey, Jen? Are the lawyers signing up people who have contracted this virus and bringing cases?
We have seen a few. There are some that are pending, but I think that given what's going on in New Jersey right now, most people haven't retained an attorney yet. I anticipate that those types of claims will be coming down the line. But it's also, the types of claims that they get filed, you're going to see not only the claims related to COVID, but you're going to see the overuse claims for the people who are working more than they normally would. So you're going to see orthopedic claims related to that, in addition to just the allegations from COVID. I think that we also have in New Jersey where claims don't always have to be filed for payments to be made. So you're still going to be handling those claims, especially when it comes to a dependency matter. There may never be a claim for those if you're accepting liability and paying. So we may be seeing them on our end where we're still facilitating and handling them, but no formal claim petition is ever filed.
I'm also seeing, in addition to everything Jen said, I'm also seeing the beginnings of certain psychiatric claims. Steve, have you heard about any of those, and what are your clients' reactions to them?
Well, I have not yet seen any psychiatric claims, Paul. I know we talked about this at the last webinar, expecting that people would have psychiatric claims in various situations. I just haven't seen any yet. I think it's still fairly new. You normally need to have a little bit of a treatment track record to bring a claim. You don't bring it on the very first day when you have a stress situation. What I'm seeing, what I'm not seeing is what has surprised me. As Jeff mentioned, there's a lot of the indirect claims where people are seeking reinstatement because they're laid off from light duty. I have not seen those yet. I suspect the fact that we have several relief bills out there, some of which are providing enhanced benefits and pay well in excess of workers' compensation pay, may be suppressing those type claims, at least in this jurisdiction. I anticipate we will see over time more of the serious COVID claims where there's a long hospitalization, large bills, death-related claims, things like that. If somebody is homesick, 14 days, no hospitalization, that'll probably be handled under other systems. You know, sick leave, short-term disability probably won't find its way into the comp system, either administratively or through the judicial system. But short answer to your question, I haven't seen any psych claims yet. I wouldn't be surprised if they weren't cooking out there and going to be filed eventually.
In a round robin way, I'd like to ask each of you this question. I'd like each of you to answer it. Steve, do you know of any client who has voluntarily accepted a COVID-19 case?
No, but the discussions I've had, some of the adjusters just presume it's compensable. Because somebody said they got it at work, they have the disease. It's because it's in the news every day. It's almost like unchallenged, and I have to advise them under the law. That you don't accept a claim unless you're sure, and I don't think you can be sure, based on the state of the medicine and the science. At this point, there's so much that's unknown about the disease. We know now it's widely communicable, can be acquired anywhere. So it's a very serious thing to accept a significant COVID-19 case without being sure. So some of these adjusters, I'm just kind of giving them a wake-up call that you still have the standard burden of proof here, and that burden of proof is not going to be easily met. With that said, there are employers who don't want to be seen as denying claims, particularly with workforce that's involved in these heroic efforts, like hospital workers, doctors. For public relations reasons alone, they don't want to be seen as being taking hard line stand with their workers. I can understand that, but that's going to create a certain tension with those employers' insurers who may not want claims accepted if there's a legal basis to deny. So we're going to see how that all plays out, but I have not seen anybody just accept a claim yet. Wouldn't be surprised if it's happening, and then we may be asked to intervene later on. We'll see.
Have you heard of any scenario, Steve, where you've told a client that it should be accepted or not yet?
I have not yet said that.
How about you, Jen? Have you heard of any of your clients accepting a COVID-19 claim, or have you ever given the advice that they should?
For New Jersey, yes. We have seen a few accepted, and none that I know of where we have a formal claim petition filed, but those where they've been notified and they've been handling it, the investigation revealed that they would be accepted under the first responder statute. So specifically hospitals and such, they have the greater protection. And so given that presumption, they have been accepting those claims, and payments are starting to be made with regard to those claims. So there have been some, and there have been some that I've advised them that under the statute it would be accepted. There are those that I've advised that they would not be accepted. So you have both sides with New Jersey, and it really depends on which statute the case is being evaluated under.
And let's break that down just a little bit more. Have you ever seen a New Jersey client pick up a non-first responder COVID-19 case, or recommended that they do to date?
Not that I've seen, and not that I would recommend. So I don't know of any that have done it. I'm sure, as Steve had said, I'm sure there's a few adjusters that may be considering it or may be doing it. But for most of them, I would hope that they would first reach out to counsel before making any determinations. But I have not made any recommendations to accept, and I haven't heard of any that have been accepted except for those the first responders.
So New Jersey has this interesting distinction. How about in Delaware, Jeff? Do you know of any
We don't
clients who have yet accepted a COVID-19 case, or have you told a client to accept one?
No, on both. I would echo, though, that it's surprising when you get questions from claims reps and their initial inclination is to accept it. I mean, that's probably not any of our normal reactions, but I think it's the human aspect of it, the realization that they probably can't go out and find work somewhere else because everything's locked down. The unemployment system is overwhelmed. And I think just naturally the human instinct is, maybe we should take care of these people. But with the state of the statute in Delaware, it's very difficult to prove a work-related COVID case. It just is. So thus far, I've not been presented with any facts where I would suggest or have recommended accepting it.
Has Delaware's legislature moved at all toward changing the law in Delaware to lessen the burden of proof for any category of employee?
They have not, in terms of the Workers' Compensation Act, done anything like that. They have expanded unemployment to where anybody that is sick or has to stay home to care for someone that's sick can apply for benefits and will be eligible, along with a number of other things. So they have taken measures to try to protect people, but as far as amending the workers' comp statute, they have not done that.
How about in New Jersey, Jen?
So as I mentioned, New Jersey has the first responder statute, but Senator Sweeney just presented, it's called the Essential Employee Presumption Bill. It's a draft of the legislation. There's a bill number that was assigned, but if you go to the legislative services, the bill is not posted. So it's unclear as to whether or not this bill will move forward, along with whether there'll be any possible changes. But it's essentially because of the quote, essential employees, they want to provide further protections for those that would not be covered under the first responder statute, because the first responder statute makes clear who would be covered. And that doesn't include, let's say, the person working at Walmart or at the supermarket who gets infected. So I think they're trying to expand it. Whether that'll happen, again, it's just in the draft stages, and right now, it's not necessarily moving forward, but it's something down the line I could see. And that would be retro back, I think it was in the bill, it had listed everything would be retro back to March 9th. So if you got diagnosed with COVID from March 9th, even if the bill doesn't pass until significantly later, you still would be covered once that change goes into effect.
Steve, the state that we share, Pennsylvania, has had some things bubble up. Can you talk about that?
Well, it's my understanding that the legislature has passed a bill to amend the Heart and Lung Act to cover COVID-19 cases. And that bill has been presented to the governor for signature, and it's expected he will sign that. That's the Heart and Lung Act covers safety officers, fire, police, certain National Guard members, and it provides for enhanced pay benefits for those injured in a line of duty, I think up to full pay, but the standards are different. It's a temporary benefit. It's not to apply in a permanent case, but there is that attempt to extend the protections to COVID-19 cases. Now, in general, the workers' compensation statute has not been amended to cover COVID-19. There was some discussion about that, but I don't think the efforts moved forward. I'm not sure why, but laws are made for political reasons. So our existing law now is somewhat different than Jen mentioned, because she talked about this first responders statute with the presumption, and that lowers the burden of proof for the employee. We don't have that yet because COVID-19 is not an enumerated occupational disease, which would get the benefit of the presumption. The catch-all provision, which will cover non-enumerated diseases that occur in a substantially greater proportion than in the background population. I think it's too soon for any scientific basis to have that provision applied, because there aren't nationwide statistics or countywide or statewide statistics that one could cite to say there's definitely a higher proportion of COVID-19 in this profession or not. Now, one would expect that among healthcare workers, but I don't think we're there yet. It's just a little bit too soon to draw those conclusions with any degree of certainty. So that leaves the claimants with the standard burden of proof, which is a difficult burden to meet in the case of a pandemic, which can be caught anywhere. And I think Jeff alluded to this earlier, that the workers' comp statute is not a terribly good template for relief for pandemic type problems. It's designed for accidental injuries and was expanded to cover more and more over time. It's really not designed well for a pandemic type problem.
I agree. I know there are some attempts to add riders to other bills to open up a lower burden of proof for other classifications of employees, but at least as of this broadcast on April 23rd, none of them have gotten sufficient traction yet. Let's move on to our final set of topics. Will any of our states, quote unquote, open up anytime soon? And I'll just lead with what I just heard in Pennsylvania. Pennsylvania is considering, I repeat, considering a May 8th reopen with a three-tiered system. Gyms, theaters, and schools will remain closed. Businesses could allow employees to go back to work depending on which part of Pennsylvania you're in, with the expectation that Northwest and North Central Pennsylvania may open first. It is a more sparsely populated area, and that Southeastern Pennsylvania may open last. I did also hear that construction projects may start again on May 1st. Still no restaurants and bars, no large gatherings, takeout food only, and there could be very many stops and starts. Jen, can you speak to the situation in New Jersey, if there's been any announcement at all?
So Governor Murphy has indicated that at the end of the week, he's going to make an announcement similar to how Pennsylvania did it with regard to phase openings. Right now, as you had said, it's Thursday, April 23rd. So my expectation is he'll have this plan put into effect or discussed at least sometime tomorrow or over the weekend. The issue with New Jersey is, given that a majority or half of the state is right outside of New York, you have a problem in that the cases in New Jersey are more significant than they are in some of the other states. And so given that, I think the opening process is going to be very slow. As I said, the courts as of now have May 11th as the date that right now nothing will be in person. And even when I think things start being in person, similar to what you said that Pennsylvania is, it's going to be very gradual. The one thing that I think is going to happen a little bit sooner than later is that with regard to pending workers' compensation claims, some of the treatment has been put on hold, especially elective surgeries have been put on hold. But I think that those are going to start being allowed sooner than later. Whether an injured employee wants to move forward with the surgery sooner, that would obviously be up to them. But I think that that's going to be something that's going to change, because some of the facilities are still providing treatment, some aren't when it comes to physical therapy or doctor's visits. But I think the biggest holdup for claims has been surgeries. So I think that's going to start sometime in May, when it'll probably be around mid-May. But I think that the businesses opening might be much longer. I think that they need to set the plan, as they have indicated, with how to get businesses that are not essential reopened while still protecting everyone. And I think that that's still an unknown across the board in every state.
How about in Delaware, Jeff? What do you foresee there?
Well, generally speaking, Delaware and Governor Carney have tracked Pennsylvania pretty closely, usually a little bit behind some of the steps Governor Wolf's been taking. But whether they're working in concert together, I'm not sure on this, but they do have some planning in place for a reopen. They have non-essential employees or businesses, essential businesses, and then high-risk essential businesses. So for high-risk essential businesses, they have a set of procedures in place to allow for screening. So anybody over 99.5 needs to report their temperature. If the business is able to test people themselves as far as their temperature when they come to work, they should do it. They're to be given essentially a questionnaire about any possible exposures or symptoms or things of that sort. So by extension, I would anticipate as they move forward, you try to extend that to essential business and then to non-essential. So there is a framework in place. They haven't come out with the three-phase color-coded situation that Governor Wolf is doing, but I wouldn't be surprised if they did.
Well, I think it all points to the fact that when we are allowed to return to our various workplaces in whatever form that it might be, we're going to be dealing with lots of increased hygiene requirements, wiping of surfaces, continuous disinfecting, taking of temperatures, and even wearing of masks along with social distancing. And of course, all of this is very much fluid and very much in flux and can change on a regular basis, which strongly suggests to me we're probably going to need a third series regarding this particular webinar in the coming weeks as things get more and more updated by our political leaders and by the ground game. And of course, we hope that everyone stays well and remains safe and follows whatever is appropriate to make sure that we can beat this virus as a group, as a country, because we're of course all in this together. I'd like to thank all of you for joining us in our webinar today, Coronavirus and Workers' Compensation. Again, you can find this webinar at our website, wglaw.com, specifically going to the icon WG University, and we will look for you at the next broadcast of this topic. Thank you very much.